looking at your CV and where you are coming from, you deserve it. You've worked so hard, rising through those ranks.
Thank you.
I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level, but here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about facts that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga, you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower court, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the bulk of the court. Indeed, when we are talking about access to justice and quality justice for that matter, it starts from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also saddled with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the conditions of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.
Chairman, my second question. Cases take so long in courts, whether rural, urban, whatsoever. Some even, eventually they die and the cases are not ended. They are not determined. Thank you for giving me the correct word. Are not determined. What is your suggestion to ensure that at least we make sure these cases are determined very fast so that we don't have so much at hand?
Thank you, Chair. There are so many factors that come into play when cases delay in court. I will not go into that because I'm being called upon to offer an advice or suggestion as to how they may be addressed. The first is that the judicial service must get their system digitalized, because now the modern trends are that if we were to digitalize our systems, cases filed will be filed electronically. When they are filed electronically, the belief that we'll have to effect service, we'll also do it, the proof of service, if it is served, you will issue proof of service and then it will be uploaded into the system. So we will not get a situation where a belief, though has served a process, will not prove service. Once proof of service is not on the docket, though the process has been served, the judge cannot go on with the case, and that will mean that the case must suffer an adjournment. When we also talk about e-justice system, we are also talking about virtual court. In other jurisdictions, even in Africa here, Tanzania and Kenya have invested so much in the judicial system such that once the cases are filed electronically and the solution of cases are generated electronically, so the Chief Justice will not even have the power or has no control over who should sit on a particular case or the other. Which means that as soon as the processes are served and everything is in place, a judge who has traveled to his hometown, maybe I might have traveled to Amasma, and if a case is put before me, I will not have excuse to say that I'm not in Accra, so I can't do the case. It's virtual court. And sometimes you can also use Zoom to do those cases. If we were able to do that, I think it will be a leap forward, so that cases will be tried as expeditiously as possible. But if we feel that we must remain where we are, we won't get far. So that is the solution I would prefer to the problem on hand. Thank you.
Chairman, what I'm about to ask might not necessarily be in the Constitution, but it's an act under the Criminal and Other Offences Act. There is this statement I've read in it that states that a child can have sex at 16, but can only marry at age 18. It has been baffling me because why do you think that someone has the right to have sex at 16, cannot marry at 16, but should wait until 18 because we say it's a law? Now, sex comes with so many things because you carry responsibilities when you go to have sex, whether at 16 or at 100. You may become pregnant, you may, a whole lot of things. What should we do? Should we bridge the gap between the 16 and 18 and make it that at least 18 is more acceptable, that the right for anybody to have sex is at 18, and when there is anything, even if you get impregnated, you could marry the one that you are interested in, or we should reduce it to 16 so that we don't even have that gap?
Thank you. I think the intent of the law, which puts the marriageable age to 18, was thinking that by 18 years, the girl would be a mature person to be able to know her responsibilities so far as marriage is concerned. Now, why should a girl have sex at 16 and not be permitted to be married? There's more of a moral question, sort of. Because look, 16 years, what does a girl know? The girl does not know anything. But if she's 18, and the Constitution even makes, I describe an adult person as 18 years. So if you are 18, the presumption is that you have seen life a little to be able to be independent or think for yourself when you are married. But if you are 16 years and they are taking you into marriage, I think it's quite. See, at 16, the girl must be in school. You should not go and follow 45-year-old man. Thank you.
Chairman, the response I was asking, with that, your explanation, I'm quite satisfied. But I need to know whether we should then we should amend it.
Amend it
to 18 years for both sex and marriage, or it should remain as it is.
To amend it to 16.
18 years.
Oh, then that the girl can have sex.
Have sex at 16.
Hey,
My Lord, I think if that is done, the defilement cases will be a lot.
I see. But the point is that let's wait to 18. That is the woman's also. If he remains in chastity to 18, well and good. But you as a parent, you will be sleeping and your daughter will be somewhere else, which you have no idea about. How can you control her? So please, let the law remain what it is, at least for now. Thank you.
Thank you very much.
Thank you, Chairman. Thank you.
Yes, Alhaji Omar, you have the floor.
Thank you, Chairman. My Lord, Philip Bright, congratulations.
Thank you.
I